Good morning, everyone. Welcome to Assembly Judiciary. Secretary, will you please take the roll?
Assemblywoman Bilbray Axelrod.
Here.
Assemblywoman Cohen.
Here.
Assemblywoman Considine.
Present.
Assemblywoman Gallant.
Here.
Assemblyman Gray.
Here.
Assemblywoman Hanson.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman LaRue Hatch.
Here.
Assemblywoman Marzola.
Here.
Assemblywoman Mosca.
Here.
Assemblywoman Newby.
Here.
Assemblyman Ortliger.
Here.
Assemblywoman Summers Armstrong.
Present.
Assemblyman Urick. Chair Miller.
Here. And with that, we're all present, so we'll go ahead and get started. Just a few reminders before we do that please make sure that you turn down your devices as to not interrupt the meeting as we go forward. Also, we will have public comment at the end of today's meeting where the public will have up to 2 minutes to make a comment on anything under the purview of this committee. Today, we do have 3 bills and 1 work session. We will begin with the work session. So, Ms. Thornton, will you walk us through the work session for Assembly Bill 404?
Thank you, Chair. Diane Thornton, Legislative Council Bureau, for the record. Assembly Bill 404 revises provisions governing civil actions against a provider of health care for professional negligence, sponsored by this committee and heard on May 9th. And there are no amendments to this measure. Thank you, Chair.
Thank you. With that, members, are there any questions on the measure? Not seeing any, I will entertain a motion for Assembly Bill 404. I have a motion by Vice Chair Marzola. Do I have a second? Second by Assemblywoman Considine. Is there any comments on the motion? Not seeing any. All those in favor, please say aye. Aye. Anyone opposed?
Nay.
Nay. So according to the hands, we have Assemblywoman Hardy, Assemblyman Gray, Assemblyman Urick, Assemblywoman Gallant, Assemblywoman Hanson, and Assemblywoman Bilbray Axelrod. And with that, the motion passes, and I will assign the floor statement to, I will go ahead and take that floor statement. With that, that closes our work session. Thank you, members, and we will go ahead and start with our first bill scheduled today, which is Senate Bill 223, sponsored by Senator Harris, co-presented by Mackenzie Warren Kay and Michael Buckley. And this measure revises provisions relating to real property. So, Senator, your hearing is open. You may proceed once you all get settled in and ready. And I know that the other 2 are down there in Las Vegas.
Good morning, Chair Miller and members of the Assembly Judiciary Committee. My name is Dallas Harris. I represent Senate District 11 in the southwest part of Clark County. Thank you all so much for allowing me to join you again to present Senate Bill 223. Senate Bill 223 is a bill that this committee has probably seen in its previous iterations. The property law section of the Nevada Bar brings a bill every session to perpetually clean up our property laws, and that is what you have before you today. I will readily admit that this is not my area of expertise, and so I am lucky to have Ms. Warren Kay as well as Mr. Buckley in Las Vegas to take all of the fire from you all today. I will, with your permission, Madam Chair, turn it over to Ms. Kay and Mr. Buckley to walk through the bill. Thank you.
Good morning, Chair Miller, Vice Chair Marzola, and members of Assembly Committee on Judiciary. I'm Mackenzie Warren Kay with McDonald Carano on behalf of the Real Property section of the State Bar of Nevada. We want to acknowledge the chair for scheduling Senate Bill 223. Also want to recognize our sponsor, Senator Harris. As you heard from Senator Harris, the section does the routine maintenance on these parts of NRS. The section is comprised of real estate practitioners that are interfacing with these chapters and these laws in their daily legal practice. The section's comprised of Northern and Southern Nevada members, and over the course of the interim, they talk about what needs to be updated. Maybe it's a reference in NRS that's simply outdated. Sometimes it makes sense to rehouse things in a more appropriate chapter that are more germane to the topic at hand. At other instances, it's finding efficiencies in the practice or to make sure that the law is capturing what they are seeing in their everyday legal practice. We've also posted a summary memo to Nellis that breaks down SB 223 quite nicely. And with that, Chair Miller, with your permission, I will send it over to Mr. Buckley to walk members through the technical aspects of the bill. Thank you.
Good morning, Chair Miller and members of the Judiciary Committee. Thank you for having us here. My name is Michael Buckley. I'm the chair of the Real Property section of the State Bar of Nevada. The basis for our bill has been well explained, and I'll walk you through the bill I'll walk you through the bill. Sections 1 through 4, we're slightly tweaking the language dealing with the recording of a lis pendens. We're changing the words from recording the lis pendens in the county in which the property or some part is located to the county of each county in which the property or any part is located. We think that's a more clear requiring that the lis pendens be recorded in every county where the real property is located, and that's sections 1 through 4. Section 5 is an amendment to NRS 40.255. 40.255 is in the section of NRS Chapter 40 dealing with eviction proceedings, but subsections 2 and 3 of this statute have nothing to do with proceedings. They deal with the relationship between the landlord and the tenant after foreclosure. So Section 5 would delete these two subsections from NRS 40.255. Section 14 will move them into NRS 118A, which deals with the relationship between the landlord and the tenant. There's no substantive change. It's just moving it out of the proceedings section into the landlord-tenant relationship section. Section 6 is an amendment to NRS 40.504. There's a number of sections in this area that deal with what happens if a lender's mortgage property is contaminated, and this section is the definition of hazardous substances. It includes a reference to the Uniform Fire Code of 1988, which no longer exists, so the proposed amendment would just delete that reference to the Uniform Fire Code. Section 7 is an amendment to NRS 106.220. We had an amendment to this section that was approved in 2021, which we thought fixed the issue here, but it didn't quite do it. The statute requires documents relating to subordination of a deed of trust or mortgage to be recorded. Almost all leases, shopping center leases, office building leases, have a clause in there that subordinates the tenant's interest to the landlord's mortgage on the whole property. And there were some people who believed that the way the language reads now, it would require the lease to be recorded. But that was not the intent. The background of this statute dealt with the problems in fraudulent foreclosures in the recession. And so we're cleaning up this language to make it clear that the only documents that need to be recorded are those that subordinate or give priority to another deed of trust, and those need to be recorded. Section 8 and 9. Section 8 is an amendment to NRS 107.015. In 2019, our proposal took a number of the definitions that were scattered throughout Chapter 107 and put them in NRS 107.015 as a general definition, so all the definitions were in one place. Unfortunately, the definition of surety and surety bond in NRS 107079 was moved also. But the word surety is used in another statute that has a different meaning. So sections 8 and 9 would take the definition of surety and surety bond out of the general definition section and put them back where they were before they were moved. Sections 10, 11, 12, and 13 are the same as sections 1 through 4, where we're just changing the language to make it clear that a document that relates to foreclosure needs to be recorded in each county where the property or any part is located. Section 15 is an amendment to the landlord-tenant law. There is an existing exemption from the requirements in 118A for a lease with the purchaser of real property. Our proposal would be an exemption for the lease by the seller of the property. In other words, the close of escrow comes, the seller wants to stay in the property for some period of time after the closing, and that's part of the deal. So this section would permit that, and of course it's permitted already, but it would mean that relationship wouldn't fall into the formal requirements of 118A. Section 16 is an amendment there's a number of statutes in Chapter 645 which deal with the broker's claim to a commission in the sale of commercial property. If there's a dispute, if the owner doesn't pay the broker has a lien on the seller's sale proceeds in escrow. The escrow agent already has the ability to, if it receives notice of a claim by a broker, has the ability to put those monies into court. This amendment clarifies that once the escrow agent puts those money in court, then the broker has to go into court and the escrow agent is relieved from the dispute between the seller and the broker. And I'd be happy to answer any questions.
Thank you so much for your presentation. Members, are there any questions? The first question will come from Assemblywoman Gallant.
Thank you, Chair. Thank you for the presentation. I know we met yesterday, and of course, as I'm hearing you present today, a question pops up, and just curious on how this would work. So we've got some rural lands where they are in multiple counties. I have no idea how far the county recorder is from these various locations, but I'm just curious if you have any detailed knowledge on like what that's going to look like for the process of the sale, and and in terms of the seller and the escrow and how that's all going to work, because obviously it's going to be an added cost if they have to record in multiple locations. I'm just concerned that there could possibly be several hours worth of driving to get from one recorder to the next.
Michael Buckley, thank you, Assemblywoman. I think the language probably already requires the documents to be recorded in every county where any part of the property is. I mean, it's certainly a careful practitioner or a title company, escrow agent, or attorney or real estate broker would make sure that the document is recorded wherever the property is. So I think it's already there, and I think more importantly, if you have real estate, it's important that the record of ownership of that real estate be of record in every county where the property is located. I mean, that's if it's not, then there could be claims against the property, or the ownership interest might be unperfected in the property if it wasn't recorded in every county where the property is. So I think in answer to your question, number one, I think it's already probably required, and number two, I think a careful practitioner would, out of even abundance of caution or prudence, record in every county where any part of the property is located. And I think the other thing, Assemblywoman, is that certainly in Clark County, and I don't know about the other counties, but Clark County has electronic recording, so I suspect that in many counties that may be the case as well. So it's probably not getting in your car and driving to the recorder's office anymore.
Thank you. Our next question is from Assemblywoman Considine.
Thank you, Madam Chair. Thank you, Senator, for bringing this bill. I think it's a pretty comparatively simple cleanup bill. The one, I guess, question that I have is on Section 10(4)C, the publishing requirement. From my understanding, some counties now don't have the newspaper of general circulation that is printed once a week. So I don't know if that's going to run into issues meeting with this. And I know that this isn't necessarily part of what you have changed in here, but just kind of wanted to bring it up. I know you all, this section meets periodically to go over it. Just wanted to bring that point up. First, newspapers are generally going away, but secondly, from what I understand in some of the rural counties, they're not having them weekly. I don't know if you wanted to comment to that, but thank you.
Michael Buckley, thank you, Assemblywoman. I agree. I think we're getting away from publishing in newspapers. I think we would certainly, our section, I speak for myself and our executive committee, I'm sure many practitioners, that it would make sense. We see it in different chapters where notices are being done through electronic mail or otherwise, and in fact, I'm sure it is a problem in places where you might not be able to find a newspaper that does that. So we would certainly, that type of change makes sense to us, and we would certainly support it.
Thank you. And with that, I don't see any additional questions, so we're going to go ahead and open it up for testimony. Starting here in Carson City, anyone wishing to testify in support of Senate Bill 223, please come forward. Not seeing anyone. Is there anyone there in Carson City that would like to testify in support? Not seeing anyone. Broadcasting, will you open the lines, please?
To testify in support to Senate Bill 223, please press star 9 now to take your place in the queue. There are no callers choosing to provide testimony in support at this time.
Thank you. Then I will go ahead and open it up for opposition testimony. If there's anyone here in Carson City that would like to oppose the Senate bill, please come forward. Anyone there in Las Vegas that wishes to give opposition testimony to Senate Bill 223? Also not seeing anyone. Broadcasting, will you open the line?
There are no callers at this time.
Thank you. Is there anyone here in Carson City that would like to provide a neutral testimony? Not seeing anyone. Is there anyone there in Las Vegas? Also not seeing anyone. Broadcasting, will you open the line?
There are no callers at this time.
Thank you. With that, then I will go ahead and close testimony and welcome the bill sponsor back up for any final remarks.
Thank you so much, Chair Miller. Dallas Harris for the record. I just wanted to thank the committee for its time and a couple of diligent questions. And I look forward to seeing you all in a few days. Thank you so much.
Thank you. And with that, I will go ahead and close the hearing on Senate Bill 223. Next, I'm going to go ahead and take the bills out of order. So the next bill will be Senate Bill 316. Senate Bill 316 is sponsored by Senator Scheibel, and makes various changes relating to criminal law. And so the bill hearing is officially open. It's also co-presented with Ms. Powers. Please proceed when you're ready.
Thank you so much, Chair Miller and Assembly Judiciary Committee, for having me this morning. My name is Melanie Scheibel. I'm the state senator for District 9, and I'm happy to be in front of you today presenting SB 316. SB 316 makes a small change to the part of the Nevada revised statutes that requires reporting for all open murder and voluntary manslaughter cases from every prosecuting agency in the state. This provision was first put into place back in 2003, and at that time there was never a requirement in law that the reports include the name and case number for the individual cases. Having reviewed the legislative history, I can't find any reason for that. Either it was assumed that people would, of course, include them in the reports, or it was simply an oversight. And so now here we are 20 years later, and prosecutors' offices are creating and submitting these reports to the Attorney General's office, but they come in aggregate form. So for a jurisdiction like Washoe County, for example, they might report that they have prosecuted 50 open murder cases that year. And they might also be able to report that 30 of the defendants were men and 25 of the victims were women. But that doesn't tell you how many cases were men killing women, because you can't connect the victims and the defendants and the cases all to one another. So this bill simply adds the name and case number for the defendant to the report that is submitted by each prosecuting attorney's office. All of this information is already public record. So there actually have been organizations that have tried to match up the numbers with the publicly available data on the cases, and it's simply a bad use of anybody's time when the information is publicly available and could have been provided all together at one time. The other change that the bill makes is it changes the responsibility of receiving, collecting, and analyzing these reports from the Attorney General's office to the Department of Sentencing Policy, because when we passed the bill in 2003, there was no Department of Sentencing Policy. And now they exist for exactly this purpose, to aggregate data from all of our jurisdictions about crimes that we are prosecuting and people we are sentencing, to understand trends better and make data-informed decisions moving forward. And that's why Ms. Powers is with me. She is a representative of the Nevada Department of Sentencing Policy, who I hope you have already heard from this session, because they do fantastic work in the state of Nevada. They are absolutely nonpartisan and provide us with really important data that, that tracks the crimes that we are investigating, prosecuting, and people that we are sentencing here in the state of Nevada, so that we can make better decisions as policymakers. And so I just want to turn it over to Ms. Powers briefly to talk a little bit about the Department of Sentencing Policy and their ability, willingness, and the advantage of having them process this data.
Thank you. Good morning, Judiciary Committee and Chair Miller. Georgia Powers, J-O-R-J-A, representing the Nevada Department of Sentencing Policy for the record. I would like to assure you that the Nevada Department of Sentencing Policy is prepared to receive and maintain the expanded data points required in SB 316 beyond the aggregate information currently being reported regarding murder and voluntary manslaughter charges filed in Nevada. NDSP exists to collect and analyze Nevada criminal justice data and to facilitate analysis and availability of the information to allow for data-driven policy decisions. As we are currently doing with prison data, NDSP can produce straightforward, useful, nonpartisan visuals and reports on trends the data shows regarding these records. Thank you.
And we're available for any questions.
Our first question will be from Assemblywoman Mosca.
Thank you so much for this. Just a quick one. I didn't see anywhere here about zip code, where the person lives or where it happened. Does that come somewhere else?
Melanie Scheibel, for the record, that wasn't included in the original bill, and so I think by utilizing the case number and the court, that would give you a pretty good idea of the jurisdiction, but it wouldn't be as specific as zip codes.
Our next question is from Assemblywoman Summers Armstrong.
Thank you, Madam Chair, and thank you very much, Senator Scheibel, for the presentation. I'm glad to see the Department of Sentencing Policy again, and really excited about you all's being prepared to collect this data and give us some clarity. I'd like to follow up on the question from Assemblywoman Mosca. Is there any reason that we couldn't include it, just so that we have some better data points to see, is there any prohibition from collecting that data? And would you be willing to just add that?
Melanie Scheibel for the record. I'm certainly willing to open up a conversation. I haven't had that conversation with the stakeholders. I can imagine that there may be some difficulty in determining, whether we're going to utilize the zip code where the incident occurred, or where the defendant lived, or where the victim lived. And so we'd have to discuss which one of those we wanted to use and whether those are going to be retained over time, but I'm certainly open to it.
Yes, please.
I think it's really important, or it could be important, to gather the data where it happened, because we know that a lot of reporting goes on, and it affects the perception of communities. It affects the insurance rates of different communities depending upon where these things happen, and that kind of data could be, either confirm that or disabuse those perceptions if we were a little bit more accurate. But you let me know. Thank you. Appreciate it.
I guess I'm wondering for what would be the purpose of having the person's name that was charged?
Melanie Scheibel for the record. That information is already publicly available, and so being able to connect the name with the case data would allow us to be able to disaggregate the information. So in a case like I mentioned, where you have a jurisdiction that has multiple cases, you would be able to divide them into which data point goes with which case, so that you could see things like, was the gender of the defendant and the victim the same? Whereas if you don't have the name of the person, you can't necessarily connect it to that case.
Okay, I'm wondering, because it says that it looks like gender's already required, and we know that names don't actually clarify gender, so how would that information be used?
Melanie Scheibel for the record. The purpose of having the name is being able to identify a particular person in a particular case. I think it's also important to recognize that as a person is prosecuted in an open murder case, they're going to go through a couple of different case numbers. So while the case number is very helpful, it's not just positive to be able to say that this one particular incident is only associated with this one case number. So by having the name, if I see that, John Doe is associated with C12345, and that was a case where, a person of this race was, killed by a person of this race, killed by, a person of this age, and a victim of this age, and then I see the same John Doe with a different case number, then I can compare the two data sets and say, oh, this is the same case. It's simply an appeal, or this is the civil portion of the case, or this might be the writ of habeas corpus that was assigned a new case number. And so that way I can tell in that jurisdiction how many different cases there were, and utilize that data that's already being collected. But without the name and only the case number, you could still have repetition of the same incident.
Okay. All right, with that, I don't see any additional questions. I will open it up for testimony. Anyone here in Carson City that would like to testify in support of Senate Bill 316?
Good morning, Chair, members of the committee. Erica Roth, ERICAROTH, on behalf of the Washoe County Public Defender's Office, testifying in support. This bill is very basic, but it means a lot, and it will mean a lot to the state, and it will allow more data-driven decisions from this body moving forward, and so we support the bill. Thank you.
Thank you, Madam Chair. John Puro from the Clark County Public Defender's Office. I echo the comments of Ms. Roth. having data and moving forward in a data-driven manner is going to move our state forward in the right direction. For a long time, we were like an airplane flying with no controls, just guesstimating what was happening. The Sentencing Commission is just a great boon to the state. They're doing great work. It's helping to inform where we're at policy, and Director Gonzalez can say, no, the data doesn't show that, or yes, the data does, and we should change direction. So this is one of those bills that'll put us in a better position. Thank you.
Thank you. Is there anyone else here in Carson City? Is there anyone there in Las Vegas that would like to testify in support of Senate Bill 316? Please turn your microphone on.
Sorry, I didn't see the button there.
Yeah, no problem.
My name is Brandon Cunningham for the record. I'm here on behalf of the Nevada Coalition Against the Death Penalty, and we're in support of SB 316. We're excited to see this small piece of legislation that'll go a long way to making an existing report more useful to help community advocates see trends in our larger criminal justice system. And we echo what other testimony that's been said here today. Thank you.
Thank you so much. Broadcasting, will you please open the lines for anyone wishing to testify in support of Senate Bill 316?
There are no callers at this time.
Thank you. I will open it up for opposition testimony. Anyone wishing to oppose Senate Bill 316, starting here in Carson City? Not seeing anyone. Is there anyone there in Las Vegas that would like to testify in opposition? Also not seeing anyone. Broadcasting, will you open the line?
There are no callers at this time.
Thank you. Then I will open it up for neutral support. Is there anyone here in neutral in Carson City? Is there anyone there in Las Vegas in neutral? Broadcasting, will you open the line?
There are no callers at this time.
Thank you. Then I will go ahead and close testimony and welcome the bill sponsor up for any final remarks. Okay, and there are no final remarks, so with that, I will go ahead and close Senate Bill 316. Next, we're going to add something to the agenda. We actually have a BDR introduction. So, members, we are going to introduce BDR number 1900 or 1900, 1-900. Again, this measure revises various provisions relating to background checks. Again, just a reminder, because it's been a while since we've done this, a vote today is just a vote to have the BDR introduced so that it becomes a bill and goes through the process. It's not in any way identifying any type of support for the measure. So with that, I will entertain a motion to introduce BDR 1-900. Thank you. I have a motion from Vice Chair Marzola. Do I have a second? I have a second from Assemblywoman Summers Armstrong. Is there any discussion? Assemblywoman Hanson?
Yes, thank you, Chair. And yes, I'm familiar with the process, so no problem. I was just curious, maybe you could hold up that BDR so we could see how thick it is? Oh, okay, thank you.
Everyone got that? Shall we have Ms. Thornton read it to us right now, or?
I do like to know what I'm voting on, so yeah,
Right.
go ahead.
We're just voting to turn it into a bill. So with that, all those in favor, please say aye. Aye. Oh,
I'm sorry, I did have one more question.
hold on, Assemblyman, you haven't been recognized. All those in favor, nay? Oh, all those opposed, nay. Okay, so the motion passes. Assemblyman Gray?
Thank you, Madam Chair. And I was just wondering why this wasn't introduced earlier, especially such a big one. I don't know what that's new to me.
The process and procedure? We will have legal respond to you for that, yeah.
Thank you, Chair. That's actually a legislative council request from my office that's exempt from all deadlines. And basically what the bill does is fixes all of the fingerprinting statutes at NRS that the FBI has rejected recently. In the past 20 years, I guess, since the last time we did it.
And just for clarity too on the process, this is probably not the last bill introduction we have, because there are emergency measures and things like that that happen, so that are exempt. So it's quite possible we'll see more bill introductions. Thank you. With that, we will continue on with our agenda and move on to our last bill of the day. Members, I want to make sure everyone has the amendment that was submitted last night, and you should also have copies. I know there wasn't really time to review it, but I believe it is on your desk. With that, I will open up the hearing for Senate Bill 235. And 235 is sponsored by the Judiciary Committee on behalf of the Joint Interim Standing Committee on Judiciary, and it is presented by Senator Scheibel and Ms. Mary Walker, President and CPA for Walker and Associates, and this measure revises provisions relating to pretrial release. And so when you're ready, please proceed.
Thank you again so much. My name is Melanie Scheibel. I'm the state senator for District 9. Happy to be in front of the Assembly Judiciary Committee this morning talking about SB 235. SB 235 is a little bit longer than the last bill that I presented to you, and it makes some very important changes and clarifications in law for what we've been calling the 48-hour hearings. And so I don't want to bore you or repeat information that is, well established at this point, but I do want to give a little bit of history just so that we're all on the same page. Back in 2020, the Nevada Supreme Court ruled in the Valdez-Jimenez case that everybody who was detained or arrested was entitled to a bail hearing in a reasonable amount of time, without actually defining a reasonable amount of time. And so in the 2021 session, we undertook as a body to create a series of laws that would protect that person's right to have a timely bail hearing and then have the bail bail or conditions set in the least restrictive manner possible to ensure the defendant's return to court and the safety of the community. So in that process, we as a body determined that we had to pick a number. So we picked the number 48 hours based on some data from other states, based on data from practice in the state of Nevada, based on some long conversations with stakeholders, decided that every person in Nevada would be statutorily entitled to a bail hearing within 48 hours of being taken into custody. Between 2021 and today, we have had all jurisdictions in Nevada start to implement this law, and as expected, there have been some challenges, and so SB 235 is designed to address those challenges. I know many of you sat on the Interim Judiciary Committee where we heard from various jurisdictions in the state that had varying different challenges in implementing this rule. And I want to make very clear that the thing that we did not do is extend the time period. SB 235 still absolutely requires everybody to get a hearing within 48 hours. And so I'll walk through the bill on the changes that it does make to help alleviate some of the concerns of our partners throughout the state. You might remember some of the more memorable testimony from some jurisdictions about the challenges they faced in utilizing remote technology and the challenges they faced with staffing. And so SB 235 does one in the amendment, which I appreciate you all taking a look at, even though it was submitted late. I've been working diligently with the stakeholders up until the 11th hour, and that's why Ms. Walker is with me today. She actually deserves the lion's share of the credit because she did the lion's share of the work to get us to a place where everybody could agree, where the District Attorneys Association, the public defenders, the judges of limited jurisdiction, the senators who worked on this bill could agree on the provisions that are contained in the amended version of SB 235. The big difference that it makes is that it includes an allocation of $1.2 million from the general fund to pay the district attorneys, public defenders, and judges who were asking to come in on weekends and holidays to hear these cases. The primary reason that we're doing that is not to pay the, the judges, district attorneys, and public defenders who already do this as part of their job, but because when there is a case where, for example, in a small jurisdiction, you have one judge who sits as both the Justice Court, Justice of the Peace, and as the municipal court judge, if they cannot have somebody else come in and cover for them, they will never get a weekend off. And as it turns out, there are not a lot of judges in Nevada who will go and sit for a justice of the peace in, I don't want to name particular communities, but who will go sit for another justice of the peace without getting paid to do so. So the purpose of SB 235 is to give each county a certain budget that they can utilize to pay a pro tem judge or a senior judge or hire another part-time judge to hear those cases, not every single time, not every single weekend, but to provide relief for those judges who are already judges, district attorneys, and public defenders who are already working evenings, weekends, other times outside of their normal Monday through Friday, 8 to 5. And so, again, that's why I brought Ms. Walker here, because she's the one who helped develop the system that you'll see laid out in SB 235 for accounting for that money, as well as the calculations for how much each county would need. Before I turn it over to her, though, I do want to walk through the bill, through the amended version of the bill, so that I can make sure I can answer any questions that you have about any of the provisions, because at this point, there are kind of a lot of them. We started out with only a few, and then over the course of this session, came to agreements on other areas where we could make changes that would, again, help every jurisdiction in Nevada to hear pretrial release hearings within 48 hours. So, Section 1 does two things. Section 1 clarifies the continuance of a 48-hour hearing. It clarifies that it can be continued for good cause. That good cause can be at the court's own motion. So if there is a judge who can't make it to court, if a judge sees that the jail is on lockdown and they can't transport people who are in custody, things like that, the judge can, him or herself, declare good cause and continue the hearing. It also allows either the prosecutor or the defendant to move to continue for good cause. So that could be that the prosecutor hasn't had time to contact the victim. It could be that defense counsel hasn't had time to talk to their client, or the case is especially complex and they don't have time to do the necessary research to make a cogent argument about their client's release standards. So Section 1 clarifies that any of those three parties can allege the good cause and the judge can grant the continuance. Subsection 3 of Section 1 also clarifies that the parties can stipulate to a continuance. And this is actually very common, especially in Category A felony cases, so sexual assaults, murders, things like that. You'll see that neither the prosecutor nor the defense attorney wants to come in 2 days after somebody has been arrested and argue bail on a case where we're talking about millions of dollars, we're talking about house arrest. Both parties will usually want a week or two to be able to talk to the other people involved in the case. As a defense attorney, I want to talk to my client's family. I want to find out what kind of financial resources they have, things like that. So both parties can stipulate that they're going to continue the hearing, and we've specifically outlined that that can be done by electronic mail or the internet. So it doesn't have to be a formal motion filed with the court. It can be if, Mary and I work in the same small jurisdiction. I know that she's the prosecutor out there. She knows that I am the defense attorney out there. Everybody knows that my client got arrested on Saturday night. We can talk on the phone and say, hey, I'm not going to be ready for a bail hearing on Monday. Are you good with Tuesday the 14th? She'll say yes, and then we'll email the judge and say, hey, we had a chance to chat, and could we please put our bail hearing on Tuesday the 14th? Section 4 relates back to Section 1, which actually has an error in it now that I see this. Section 1, we have discussed amending the provisions of Section 1 to allow for the 48 hours to start at the time of booking, unless for some reason more than 8 hours passes between arrest and booking. Which I know sounds complicated, and it took us a while to get to this place, and here's the reason for it. For most jurisdictions, the time of booking is much easier to calculate. That is a timestamp when the person enters the jail. It is easy to refer to, and generally, booking comes shortly after somebody has been taken into custody. Calculating back to the time that somebody was taken into custody has turned out to be administratively onerous without having a big advantage to defendants, because most people are being brought to their hearing within 48 hours, and a lot of them are actually being brought to their hearing in even less time, in 24 or 16 hours. So the stakeholders, we all kind of agreed that going from booking to 48 hours would not substantially change the rights of the defendant. We also discussed the fact that there could be an outlying case where there is an offensive amount of time between the time that somebody was arrested and the time that they were booked, and we don't want to open up the opportunity for bad actors to abuse the change and keep people in custody for long periods of time before they're actually booked. So we talked to our partners, especially in rural jurisdictions where they actually do have to drive significant distances, and decided that there's really no reason anybody should spend more than 8 hours in custody before they're booked. So the way that this would work in practice would be, generally we don't think that there are going to be significant problems with this issue, but this would allow, if, for example, I work in a particular jurisdiction, I'm the public defender out there, and I have a client who comes to a hearing on a Monday morning and he says, well, I was booked on Thursday, or I was taken into custody on Thursday. And then we look back at the records and see that he wasn't arrested or booked until Friday afternoon. Subsection 4 then comes into play. That gives me the statutory authority to go to the court and say, my client was entitled to a hearing earlier than today, and all of the attendant remedies would then follow. It will be retrospective in many cases, but the purpose of subsection 4 is to ensure that if there is a pattern of abuse, that we're able to catch it. And for any individual who is held for more than 8 hours before they're booked, and it affects their ability to have a hearing within 48 hours, we do want to have a remedy. Or you could catch it in the middle. That's another example. So if my client is arrested on a Tuesday morning and calls me, and I go to talk to him, and he says, hey, by the way, I would tell him, you haven't been scheduled for a pretrial hearing either. When were you first brought into custody? And he says it was Sunday night. Then I'd be able to contact the court and say, hey, we're coming up on 48 hours of being taken into custody. Even though he wasn't booked for 10 hours, he's still entitled to his hearing this afternoon, if I wanted a hearing this afternoon, which again goes back to subsection 3. If my client was in custody for 9 hours before being booked, it's probably on an incredibly serious charge, and so I might not want my hearing in 48 hours anyway. I'm sure there will be questions on that section, but I wanted to kind of lay it out for you, and then I'll be happy to address those specific questions. Subsection 6 of section 1 just clarifies that anybody can appear by remote appearance. They were already allowed to do that, and some jurisdictions didn't feel the language was strong enough, and they were, I think the legal term is nervous about doing it, and so we wanted to make sure that everybody was empowered to utilize the virtual technology available to them to conduct these hearings. Section 1.5, I've copied into the amendment just for ease of reading. There's no changes to Section 1.5 from the original bill. And what Section 1.5 does is clarifies that if somebody is brought back into court after they've already been released pre-trial, that the court has the option to impose additional conditions before they are re-released. So what would this look like in practice? Let's say I have a client who was released without house arrest, but the order was you can't go back to the Tropicana because that's where this incident occurred, and my client is found in the Tropicana and brought back into custody. So the judge might not want to revoke bail and keep my client in custody. The judge might want to impose a new condition, which is house arrest. We're going to let you out again, but this time you're going to be on an ankle monitor and you're not going to be allowed to leave your house. And so Section 1.5 ensures that judges have that option as well when they are addressing a violation of a pre-custody release order. The new section, Section 3, is the money part. And as I described briefly at the beginning, I'll let Ms. Walker kind of walk through those amounts. But the way that we envision this working, having talked to DHHS and DIDS, the Department of Indigent Defense Services, and the Controller's Office, we think the most efficient way to do this would be to make those allocations in the statute. And then the controller would deposit those amounts in the accounts of each of those counties, they would be able to use that money to pay a stipend of $450 per day for any judge, defense attorney, public defender, prosecutor who works on a weekend or a holiday. And then they would have to account for that money. They would return anything in excess of what they were already given. There's no punishment the next year or anything like that. And then they're also required in subsection 3 to provide a report to the Legislative Council Bureau to report to either the interim Judiciary Committee or the Judiciary Committee, depending on the year, so that we would all get to see how much they're utilizing these funds, when they're utilizing these funds, and who they're utilizing them for. Section 4 is really long because I had to copy the entire statute into Section 4, but the good part is on page 8. And page 8 says that a justice court, justice of the peace, and a municipal court judge may, if they both agree to it within their own jurisdiction, sit for each other during these pretrial release hearings. It also clarifies that we have I know a couple at least, of jurisdictions where one person sits as both the justice of the peace and the municipal court judge, and they can't combine those calendars right now. So what's happening is that the same judge is sitting in front of the same prosecutor, the same defense attorney. They're going through 2 or 3 pretrial release hearings, and then kind of like, if we had to, kind of like when we go into joint session and we have to close the session and then go back to our own sessions, they're doing the same things with their clerks and their recorders and their marshals or bailiffs, and they're shutting down court and then reopening court because they're moving from the justice court calendar to the municipal court calendar. And so by allowing the justice of the peace or municipal court judge to hear cases for the other judge, that would allow them to just have one calendar. So if the justice of the peace has 3 justice court cases on that day and 1 municipal court case on that day for a pretrial release hearing, they can just add the municipal court hearing to their calendar and hear them all together. It would also allow, in jurisdictions where the justices of the peace and the municipal court judges agree on it, it would allow them to sit for each other. So it could be a municipal court judge hearing an entire justice court pre-trial release hearing calendar. Not the preliminary hearings, not the status checks, nothing except for the pre-trial release hearings. Section 5 basically does the same thing in the opposite direction, allowing the municipal court judge to sit for the justice of the peace. So between sections 4 and 5, you get the cross ability to sit for one another between justice court and municipal court. But all of that has to be done pursuant to an interlocal agreement. So both courts have to agree to it and put that in writing before that can happen. Section 6 provides for something kind of similar for district attorneys and would allow deputy district attorneys this is especially for our rural communities, to be what we have termed cross-deputized to represent another county in a pretrial release hearing. So to give you an example, if I am the Nye County District Attorney who has 2 deputy district attorneys, and the Lincoln County District Attorney's Office, which has 0 deputy district attorneys, wants to borrow an attorney for a day to do pretrial release hearings so that the district attorney in Lincoln County can go on vacation or, I don't know, be sick one day, then that would allow, if they've agreed in advance, for the Lincoln County District Attorney to deputize a Nye County Deputy District Attorney to go sit in Lincoln County and do those pretrial release hearings. And they would get the $450 stipend because, back when I worked for the District Attorney's Office, I certainly wasn't going to anybody else's jurisdiction just because they asked me to. But for $450, I might. So that is what Section 6 says. Section 7 is the enabling language to allow a district attorney to accept that $450 stipend. And Section 8 is the equivalent for the public defender, deputy public defenders, and appointed counsel. It did come to my attention that we will need an additional Section 9 to cover the state public defenders, but it will be similar or the same language, just not confirming, but authorizing those individuals. So it could be either the public defender themselves, the deputy or assistant public defender, or it could be contract counsel, somebody who's appointed to represent indigent clients in a rural jurisdiction, or the state, in any jurisdiction, rural or not rural, or the state public defender. All of those people, the people who are going to get put on call on Christmas Day, if there are any pretrial release hearings, can earn their $450 to do so. And I think that covers the main sections of the bill. I'd like to give Ms. Walker an opportunity to kind of expand on how we got to the section, I think it was 9, section 3, if you would like, or we can go straight to questions, whatever you prefer.
Ms. Walker, do you have anything to add?
Thank you, Chair Miller and members of the committee. For the record, Mary Walker, representing Douglas, Lyon, and Story counties. I first wanted to thank Chair Scheibel, Senators Nguyen and also Harris. They have worked very hard with us, sat down and met with us many times, and really appreciate their dedication to try and resolve some of these problems. As Chair Scheibel stated very accurately, you know, the burden of, the rural counties had a difficult time implementing AB 424. But it really, the true burden of it was the judges, district attorneys, and the public defenders. They're all salaried, so they don't get any additional compensation, and all of a sudden they have to work weekends and holidays. So what this does is this provides them this stipend. How we calculated it, it's equal to 3 hours at $150 per hour. So that's the $450, and it can be utilized by the existing judges if they have to work, or getting other folks in. I have one judge; she's had 4 days off this year, and it's particularly hard when you have one judge, one district attorney, one PD in an entire county. There is nobody to come in. So by providing this stipend, then we are going to be able to incentivize folks to come in and actually help provide this service. But the other big thing this does is it also helps us to grow the pool. As you know, the rurals are in a very difficult situation in regards to professionals. We don't have a lot of doctors or nurses. We're short teachers. Our police departments, our sheriff's departments are short staff, that whole thing. And attorneys are in there. So what this does is it helps grow the pool by being more flexible to allow, say, for example, the state PD to come in and work this, and they get a stipend for it. You may have a Clark County deputy district attorney that comes in and helps, you know, some of the rural counties as well as rurals helping each other. So I think this is a really big deal in helping to grow the professionals that we need in order to get this to work, and provide the time off for these judges, district attorneys, and public defenders. If you want, in total, how these amounts were calculated is we surveyed just about all the counties. There are a couple of little ones I didn't get to, but let me give you an example. In Elko, they actually have 4 courts, but what they do is they pull the judges and the courts so that on weekends it's only one judge working the weekend. So what this anticipates is that continues, and we pay a stipend to that one judge who is working weekends. And they have so many cases, they actually have Saturday and Sunday court. Some of the other jurisdictions only need to have 1 day, and this is all to meet that 48-hour provision. Some courts only need 1 day on a weekend, so they will just get one stipend of $450. If you work 2 days, you get $450 for 2 days. So it's based on what their current process is. And I think the rurals, counties, the judges did a great job in a lot of these areas Lyon County is one, Nye County is one, as well as Elko, that they're pooling these judges. So maybe a judge only has to work one day every 3 weeks or one day a month. But whoever is working that is going to get that stipend. So that's the whole theory of it. In total, it's almost 1.5 million for that. It's just for the weekends work. We're still discussing, holidays and how we address holidays, but that's where we are at this point. And again, I want to thank particularly Chair Scheibel for all the work and effort she's put into this. And the Joint Interim Judiciary Committee, you guys started this, with Chair Scheibel a year ago. You've been working on trying to fix some of these problems for a year. And the meetings that you had over the interim were just wonderful. And so I want to thank you very much for all your efforts. And any questions, I'd be happy to answer.
Thank you for that. The first question is from Assemblywoman LaRue Hatch.
Thank you, Chair, and thank you for being here to answer these questions. My question is on the new Section 3, Sub 3, where it says the funding should not be used to pay any further staffing costs. I'm a little concerned because I know that these cannot happen without IT and without clerks and without everybody else. So can you just explain why we wouldn't be paying those individuals?
Thank you. For the record, Mary Walker, thank you very much for that question. What we tried to do is have a narrow focus to hit the most problematic areas. We didn't add this additional staffing, even though a couple of jurisdictions did ask to add that. But those staff are already under a contract. They're under a union contract, so if they work on weekends, they're going to have overtime pay, that kind of thing. Whereas the salaried judges, DA, and public defenders, they're not getting anything. So that's it. So what we feel is that's the responsibility of the local governments, is to provide that staff. And that's why that wasn't included in that, but I really appreciate your question.
Sure.
Thank you for that. I just want to confirm, is every staff member in every one of those courts unionized?
I don't, for the record, Mary Walker, I don't know. For the most part, they would be. Just court staff, they're under the same union contracts as your general employees. But there could be some staff members that are unclassified, but I do not know that. But for the most part, they're going to be under a union contract. And we feel, if there needs to be additional stipends or whatever, the counties would be able to pitch in that for the staff. We just, as a policy matter and as a matter of trying to keep the dollars down, we just made a point that says, okay, this is what we're going to pay for, and then the counties pay for the remainder. That was the policy decision.
If I may follow up, Melanie Scheibel, for the record, I completely agree with Ms. Walker. It is unacceptable to have staff working on weekends without paying them, and we did talk to the courts and the various jurisdictions who are in fact paying the clerks, the IT, the marshals, because of the union contracts. And so if there were any jurisdiction that wasn't doing that, I would certainly want to know about it. But from a legal standpoint, like Ms. Walker said, that is the responsibility of the local governments. And I'm open to conversations. Obviously, I don't control the budget, but I'm open to conversations about whether their budgets need adjustments. But basically, the policy agreement is that those staff members are the responsibility of the counties or the municipalities. It's the professional salaried staff that we're trying to incentivize to add to this pool that the policy decision is saying the state should contribute the money, since we're the ones who gave them the 48-hour rule.
Sure.
Thank you for that. I do have deep concerns that we are looking to pay our judges when it is their staff that supports them. I mean, we couldn't do our job with our staff here. And many of them are salaried. Many IT professionals are salaried, so they're not getting additional hourly compensation. I think they are currently being asked to do this without additional compensation. And I would ask, if the logic is that the municipalities and the local jurisdictions should pay those staff, why should they not pay the judges? Why are we making a distinction between two different classes of employees?
Melanie Scheibel, for the record. If there's a jurisdiction that is asking court staff to come in and not paying them overtime for weekends and evenings, I definitely want to know what jurisdiction that is so that we can address it, because that, like I said, is unacceptable. And the reason for increasing the budgets here is that the idea is to pay all of those staff members and to not put the onus on the counties or the municipalities to create all of those budgets. They have limited budgets as it is. And so the policy perspective is that as lawmakers, it's our obligation when we put a obligation on a local government to do something within 48 hours, we have to give them the support to do that. We could invert it on its head. We could say that the counties are required to pay judges and PDs and district attorneys for the time that they work on the weekends, and we'll cover the cost for the staff, but that would be more expensive to the counties and less expensive to the state. And so I think that this strikes the right balance of us taking responsibility for the 48-hour rule that we implemented. And I also want to emphasize that we're not just talking about paying the salaried employees who are already doing these jobs. We're talking about bringing in relief staff, and we're talking about getting those judges, district attorneys, public defenders to work across county lines to provide services outside of their normal job duties. And so in a state where we're already struggling to staff our public defenders' offices, our prosecutors' offices, we really can't afford to just hope that people will be nice enough to step in and cover for another county without compensating them.
Yes, please.
Thank you, Chair Miller. For the record, Mary Walker. Just to add one more thing to Chair Scheibel's discussion points. There are several rural counties on the judges where the judges come in and they not only do their jobs, but they're doing their staff's jobs. They have trained themselves on the staff's computer system so that they can do that. So they're working two jobs, and it's very simply to allow the staff to be able to not come in to work on weekends and holidays. So I mean, it's amazing what these judges are doing. Thank you.
Our next question is from Assemblywoman Gallant.
Thank you, Chair. I understand that you guys are trying to give the judges and staff time off. And I guess I don't really quite understand the history from last session, right? It was 2019, you said it was?
Melanie Scheibel, 2020 was a Supreme Court decision. 2021 was when we implemented the pretrial release hearing legislation.
Okay, so, I mean, I just see burnout on this, like, across the board, and so that's one of my concerns. We can't ask people to be working weekends after weekends and do this for an entire career, right? Decades. I also have some concerns about the fact that, like, you know, I think about like my family, who are very conservative Jewish, like extended family. So from sundown on Friday to sundown on Saturday, there's no electricity, there's no work. They are observing their religious beliefs and practices. And so how does it fit into this as well? So I'm worried about it just, you know, infringing upon religious rights. So I'm wondering, like, why is it this particular type of cases, like this criminal with the bail hearings, when every other court kind of does the within an X amount of days or an X amount of hours or the following business day? Why are we making an exception here when we don't do that for any other court cases? And wouldn't it be more financially responsible if we could get it in line with the, you know, standard practice within the judicial system?
Melanie Scheibel for the record. So I think what you're asking is why 48 hours and why not just extend the time? And there are a couple of reasons for that. So first, let me go back and talk about the religious freedoms and the burnout and the expectations that we place on our professionals, because I agree, and what we saw during those 2 years after we implemented this statutory scheme and today is that people are burning out and they are not, it's not working. And so that's why we came up with these solutions to allow for more coverage, more relief support. There are pro tem and senior judges. So, and if you don't know what a pro tem or senior is, a pro tem judge is somebody who doesn't sit as a judge normally, but comes in kind of like a substitute teacher. A senior judge is a judge who has left the bench, but still comes in and covers for other judges. Again, kind of like a substitute teacher. They come in for a day at a time or a calendar at a time, or a week at a time, whatever. And so we talked to senior and pro tem judges in those rural jurisdictions that were, struggling the most, and learned that they would be willing to do this if they could get paid for it. The problem was that the counties have in place a mechanism and a budget to pay pro tem judges to cover, a regular calendar for however many days or a year the judge normally gets vacations, but that wasn't covering the weekends. And so that's part of the purpose of this, is to expand the pool so that people do get more relief, so that they can have that time off and avoid burnout, and so that we can better implement the rotating schedules that Ms. Walker talked about. You might have 2, 3, 4 jurisdictions that pool all of their pretrial release hearings, because it might only be 5 or 6 or 7 hearings, and they don't generally take that long. We're not talking hour-long hearings. We're talking, I've done 5 hearings in, 20 minutes, but you could probably finish 5 or 6 hearings in the 3 hours that people are getting paid for. And so to better allow pooling, so that if there is somebody who can't work Saturdays, their shift is scheduled so that they only ever get assigned to Sunday court, or they only ever get assigned to the weekend court, and they don't get stuck having to work on a Saturday. I also want to point out that we have plenty of other public servants who work around the clock. And in fact, that's how this all started, is that our police officers work 24/7. They don't take breaks on weekends or holidays. And so the rest of the judicial system has to continue to function outside of normal court hours. We already have judges who are on call for search warrant duty, and that usually lasts about a week, and they have to answer their phone at all hours of the day or night in order to, approve or deny search warrants for law enforcement officers, again, because law enforcement works 24/7. And so in terms of aligning the time frame of the pretrial release hearings with other judicial hearings, I will say second of all, I guess, that there are other hearings that have to happen in very short periods of time. Temporary protective orders are within 12 or 24 hours. Those are very quick. And in 2020, when the Nevada Supreme Court decided the Valdez-Jimenez decision, they specifically, I want to rephrase that. The ruling required that the hearing be held, quote, promptly, without defining promptly. And so it was left to the legislature to come up with a definition of promptly that met the legal standard that's set forth by the Supreme Court, that met the legal standards that we've seen from the U.S. Supreme Court and other jurisdictions. And that's how we landed on 48 hours, is that it is a reasonable amount of time from the time that somebody is booked to the time that somebody is seen, that allows for, we purposely picked 48 so that there's a 24-hour time period in the middle where if a judge, prosecutor, or defense attorney absolutely could not be present, you always have that 48-hour buffer, which includes 24 hours in the middle, so that there's no one day of the week that you would absolutely be stuck having court. And so I think that it is also an incredibly important constitutional right to a fair and speedy trial, and it is a person's right when they are detained to be seen in a timely fashion. And so coming before a judge within 48 hours to have release conditions set is now an important facet of the Nevada law that we worked really hard to develop in 2021, and we're continuing to work hard on to implement it and to make it work. And so I think that maybe another way to answer your question is that we're not ready to give up yet. That there are ways to make this functional without having to sacrifice that protection that we put into place for people who are accused of crimes but who have not yet been convicted and who remain innocent until proven guilty.
Assemblywoman, was your question answered? Yes, please. We do need clarity.
So I appreciate that you guys are continuing to try to attain this 48 hours. And I understand it was left to interpretation within the Supreme Court ruling. So there is some wiggle room, I would think. So I guess for me, I would like to request if I can find out what it is like in, other cities across the United States and like what their standard is and how we fall into it, to see if there is a way that we can find something that like works for everyone that wouldn't necessarily cost the state more money.
Melanie Scheibel, for the record, we did hear from other jurisdictions and from the National Council of State Legislatures over the interim, and we heard from other jurisdictions that do them within 24 and 48 hours. And then there are others that do other timelines, but I think we looked specifically, I'd have to refer to the minutes. We looked specifically at other states with similar demographics and similar population sizes that do 48-hour hearings. Oh, sorry, Melanie Scheibel. Yeah, we'll definitely follow up with you. Yeah, sorry. That was what I
And
meant.
please submit that to the committee, please. Our next question is from Assemblywoman Hanson.
Thank you, Chair. And thank you for being here. Thank you for the work you've done. I totally agreed with the intent in 2021 of, what was it, AB 424, but had grave concerns about the rollout. And we're here, and this is what we do. This is not new, but so glad to see that this work has been done, and appreciate that. Having so many rural jurisdictions, so I appreciate the deputizing of the DAs, the over other areas, and all that work. And then to the appropriation, I get it. And that was probably, we put the cart before the horse. We didn't have that tied to the original. And so here we are. And guess what? A Republican doesn't have a problem with that, because we can't do this. And I really believe that what came out of the Jimenez-Valdez decision was really important. People are innocent till proven guilty, and they are entitled to, and 48 hours when you're in custody like that, that's a long time, especially if you're innocent. So totally appreciate that we're, as a state of Nevada, trying to comply with that Supreme Court decision, which I thought was a very valid decision, being a layperson. So about the money, I heard you mention that the allotment that they get, the amount, will go to the county, and whatever they don't use reverts back to the general fund. So how often is it every 2 years then that we have to decide as a legislature how much they get? So if things go up, or maybe their budget was lower, so it's every 2 years then?
Melanie Scheibel, for the record, great question. And we did think about this, and the solution we came to, and I'm open to other suggestions, was to put these numbers in statute, and each county would get the amount specified on this list every single year on August 1st, or prior to August 1st, they would get that, unless we change it. I think it is and then we have the reporting mechanism in there so that we can change it if we see that we need to adjust up or down. But the idea is that it's not going to expire. They're not only going to get it for this 1 year. If we do nothing, they would continue to get the same budget every year.
Chair, just a quick follow-up.
Please.
Thank you. Okay, and then we do have that oversight. to review that. The other thought I had in regards to staff and weekends, and I don't know if this really would work this way, but I know in some of my communities, there are people that would love to be involved in the legal system, but they don't have the ability to do that on a full-time basis. So they might have weekends free, and they might really want to be involved to serve in this capacity. And so I see that as a flexibility that it would allow for part-time work instead of straining full-time workers. So just wanted to throw that in.
Thank you. And with that, I do want to remind everyone that the appropriation that's put into the bill changes the whole process for the bill, and that this is a policy committee and that we're fleshing out the policy and whether or not this committee feels that that policy is appropriate or necessary, not the dollar amounts or putting into statute dollar amounts or even funding the bill. With that, our next question is from Assemblywoman Summers Armstrong.
Thank you, Madam Chair, and thank you, Senator Scheibel, for another interesting presentation, and we appreciate you also being here, ma'am. Can you just kind of help us dig in a little bit more on page 1, section 1.4? If more than 8 hours elapses between the time a person is taken into custody and the time of booking, the pretrial release hearing must be held within 48 hours after the person was taken into custody. Can you just kind of explain, is there a standard practice of reporting when someone has entered into a correctional facility or the jail? How is that captured? And yeah, can you just kind of explain?
Absolutely, thank you. Melanie Scheibel for the record, and I do want to clarify, this is my fault, in section 1 also, in subsection 1, where on like the 4th-ish line where it says within 48 hours after a person has been taken into custody, there was an amendment to change that from taken into custody to booked, and I failed to include it in this amendment. It is rather important. And so to answer your question, the reason that we're changing it or proposing to change it from time taken into custody to time booked is that the time booked is something that we can track, but not the time that someone was taken into custody. So I think an apt comparison would be like when you get to work. If you're a person who has to clock into work every day, we can tell the exact time that you clock into work, but we can't necessarily tell the time that you parked or the time that you left home. And so what we're suggesting is that the time from when you're taken into custody to the time that you're booked is relatively short. However, if there were some extenuating circumstance where it took way too long, we want to be able to address it. So it's kind of like if, we want to know what time you got to work today, we're going to look at when everybody clocked in. But if somebody says that they left the house at 5 a.m. and they didn't clock in until 9 a.m., we're going to say there's something weird going on here. The problem is that we don't have a system for tracking when people are taken into custody. We can go back and look at circumstantial evidence, but it's not that defined moment in time. And so instead of continuing to fight over a couple minutes or even an hour earlier or later on when someone was taken into custody, the stakeholders agreed that just using the booking time, which is, digitally set and listed on the arrest report, would be easier to track. But if you had a report from a particular individual that there was a discrepancy between the time they were taken into custody and the time that they were booked, they would still be entitled to the hearing within 48 hours of being taken into custody.
Please.
Okay, thank you for that description, and I have a real concern here. I don't know what stakeholders you're speaking of on this, but it's my understanding that let's say we have a traffic stop, okay, so you kind of correct me if I'm wrong, because I'm not an attorney or anything like that. But when someone is stopped on a traffic stop and the person says to the, well, I want to ask you questions, and they say, well, no, I'm not going to answer. And then they say, okay, well, I'm not going to let you look at my car or whatever. And the person says, well, then you're under arrest. That person is now in custody. Is that correct?
Melanie Scheibel, 100%.
Okay, so that person is now in custody. They spend some time in the back seat of the patrol car while the officers look at their vehicle, gather any information, and then they are transported, whatever distance that is, to the jail, right? Can they be interrogated before they are booked?
Melanie Scheibel, for the record, yes, they can.
Okay, so then I have a problem with this because we need to be honest about what it is when a person no longer has the agency to get up and leave. And once that person doesn't have the agency to move and leave, that should be where the clock begins, which is why I believe custody was the original intent here. And I have a problem with us now making a situation where a person can sit in the back of a squad car, wait to be brought into a facility, be interrogated, and then booked. This could last for hours, and then you're adding all this time now that they are without liberty before they get to have a hearing before a judge. So I have a real issue there.
Melanie Scheibel, for the record, and I don't disagree with you, and you are exactly correct about that is why we started with 48 hours from the time someone's taken into custody. I would encourage the public defenders who are going to speak in support to maybe provide a little bit more color to why going to booking was, with the 8-hour limiting language on the back end, was a workable solution for them. It was their suggestion to design the statute in this way, to utilize booking with that subsection 4. And, I'm open to either way of approaching the bill.
You're welcome, Assemblywoman. I would actually, Assemblyman Gray, I still have you next. So I would actually like to call Mr. Pirro up, not for testimony, but I do have a few questions for you. So as a public defender, because again, as the Assemblywoman mentioned, this time, and using the analogy between when we pull into work and when we punch the clock, I don't think is a well thought out analogy at all, because again, we're talking about two completely different things. And so based on what the Assemblywoman said and the hours and hours that can go between the moment that someone loses that freedom to the moment that they actually get to the jail, let alone any type of booking or proceeding or, and again, I think we need to bring this back to this is about pretrial release. And this is our constitutional obligation, pretrial release, not paying judges and lawyers, but actually pretrial release. In your experience as a public defender, you're the one that shows up. What is the average amount of time? What's the longest time that you've seen between this stop or arrest or detainment and the actual booking?
John Pirro for the record. That's a difficult question to ask, but I can tell you anecdotally that most times, unless it's a major investigation and we're talking about murder or sexual assault, those are when people are going to be pulled to the station, or a series of robberies where the police are trying to put together evidence and want to interview the suspect before. That's going to take a few hours. And I think that was the idea between the 8-hour cap, basically saying, like, either it's going to be booked. So like in a traffic stop situation, traffic stop happens, the person happens to get arrested, he's going to be brought to the station as soon as that, and our legislature has said, unless something more is going on, you can only keep a traffic stop for 60 minutes. Other than that, if nothing more is going on, you have to let that person go. So that person's going to be brought to the station, and be booked and then have their hearing within 48 hours. Does that answer your question?
So we're getting there. So basically, so in a typical traffic stop, and you're just using the example that there may be probable cause for something else or a warrant, there's some reason now to arrest them. It's 60 minutes. And then, but we also know there's still incidental time. There's travel to the jail. There's all that kind of stuff. So 60 minutes would be the traffic time, but how much time can actually lapse between, and I guess you know this as a public defender because you're coming in and the first thing you're seeing is these booking reports. So how much time is actually lapsing?
John Pure for the record. Again, it's going to be different across the state, and I'll say this, and just to expound a little bit, last session this legislature decided in accordance with the Valdez-Jimenez case that prompt means 48 hours, which was a great decision that this legislature made. Unfortunately, prompt was not meaning the same thing all over this state before that. If Assemblywoman Hansen got arrested, prompt in her jurisdiction could have meant a very long time. Even in Henderson and North Las Vegas, prompt could mean a few days. So we decided that 48 hours was the marker for prompt. In Clark, though, we collaborated and we have the initial appearance court where you are seen within 12 to 24 hours of arrest. Like, we are moving forward with that. This bill is meant to kind of fix that and find some workable framework for the rural jurisdictions. We settled on 8 hours. We're trying to do our best because there was one jurisdiction, if I may, Lincoln County, which had Lyon County, I'm sorry, thank you, Mary, an offensive 9.5 hours between arrest and booking. But other jurisdictions are keeping it maybe 1 hour, 2 hours, a few hours. So we're trying to move this process along and give the rural counties time to get a person processed, get them before a judge, and see if they should be released. And frankly, I do think this bill does strike the right balance.
With that, because what we're trying to get to is this 48-hour goal. What we don't want to do is extend the time. And so the chord was struck when between the language of saying between taken into custody and booked, because we know that there is additional time. So if we're talking about 48 hours from booking, that's not 48 hours of liberties being limited or detainment or anything like that. So that's what we're trying to get to, that it's not another creep increasing on those 48 hours. And I guess I should just ask, and again, taking out, murder and sexual assault and these, robbery syndicates and stuff like that, just taking those out because we know those are more extraordinary and require much more extraordinary handling. But with this, why isn't it just from the moment of arrest or the moment of the stop? Because again, with traffic cams and all that kind of stuff, we do have the time. We do have that data from when that person was stopped, whether it was vehicular or not.
John Pure for the record. I just think this bill is trying to take that portion into account, those extraordinary cases. I don't think that 48 plus 8 is going to be the standard. I think it allows for that investigation that may need to take more time, but the majority of hearings will start from the time somebody gets to the jail within 48 hours, and in Clark, sooner.
Okay, Mr. Pirro, there are a few more questions for you. Assemblywoman LaRue Hatch.
Thank you, Chair. So I just had a question. We heard at the beginning of this presentation that you could request for the hearing to be later. Like, let's say it's supposed to be tomorrow and you say, no, I'm not going to be ready for tomorrow. Make it 2 days from now. How often does that happen? Do you typically need more time, or are you more often wanting to get right in there with your client?
John Pirro for the record. It's really going to be a case-by-case basis. If somebody's alleging sexual assault, even if you get an allegation of that allegation alone can ruin your life if it's not true. So it's very difficult to get somebody out on those charges. Same with a murder allegation. So you want to collect all the evidence because you want to have a really robust bail hearing in front of the judge that takes into account all of the person's life history, their contacts with the community, what they do for work, maybe some of the facts of the case that you're going to argue in that bail hearing, to try to get either bail to an amount that a person can afford if it's justified, or at least have that person put their best foot forward in front of the judge to have the best chance of getting out. So there are occasions where we're going to ask for more time to make sure that because it's a one shot, one kill kind of deal. If I go in there and I do a crummy job and bail gets set at $1 million and a person sits for years and years and then we get a not guilty, well, I still ruin their life because I was unprepared at the outset.
Thank you. Assemblywoman Hanson has a question.
Thank you, Madam Chair. Thank you for coming to the table. Could you clarify, so real quick, when we're dealing with this situation, this is warrantless arrests, right? And so when you talked about, and then we're doing the Nevada determined 48 hours in 2021 in response to Jimenez Valdez. But then, Mr. Pirro, you mentioned that in traffic tickets, if there's nothing else, it's 60 minutes, right? So it's even quicker. And so the courts are doing that now. What happens if it happens on a weekend? Does that apply? Because we're talking about sometimes the court has to do work on the weekend, but if I understood you right, you said sometimes 60 minutes is all that's allotted in a traffic stop. Do you mean you can only hold them there at the place for 60 minutes? Okay.
Jump here for the record. If the police officer stops a person, doesn't find anything, right, that's the limit of time they can hold them.
Oh, okay. Thank you. I apologize for my confusion. Thank you.
And jump here for the record. That's the limit of the time they can kind of try to find something. Like, oh, yeah.
Thank you for that, Mr. Pirro. With that, we'll let you, and we'll continue back with thank you for answering those questions. Again, we're just trying to get at that extension. And with that, our next question will be from Assemblyman Gray.
Thank you, Madam Chair. And just real quick to Mr. Pirro's last comment, yeah, a lot of times it can take a whole lot longer to get a canine out there than 60 minutes. So anyways, I wanted to thank Senator Scheibel and you, Ms. Walker. This being on the county side of things, when this came down, I mean, it was a ton of bricks that came down on us. So this little bit's going to help. I'd like to see a little more flexibility maybe in how the money can be spent. Because there was a lot of technology that's involved for remote stuff, and especially when you look at Lyon County and other jurisdictions. But thank you guys. Every little bit helps when it gets to the rural counties.
Our next question is from Assemblyman Ornlicker.
Thank you, Chair. Thank you for the presentation. So I may have missed this, but I'm not clear about the point you said. If I'm recalling it, that there's not as the same precision on when the suspect is taken into custody as when they're booked. So I'd just like a little more on that, because I would have thought you take him into custody, you put him in the patrol car, and that the peace officer at that point would say, make some official create a record that they've taken the person into custody. Is it that we don't trust that, or is that, I mean, why is that not a precise time?
Melanie Scheibel, for the record. There are two reasons that it's not a precise time. The first one is that there is not a official and standardized record of when somebody is taken into custody. So if I am the clerk who's in charge of reviewing all of the arrest reports from the day and putting them on the schedule for the 48-hour hearings tomorrow, the arrest report is only going to come in with the booking time. And so as I'm comparing the booking time to tomorrow's hearings at 8 a.m., noon, and 3 p.m., I'm going, okay, this one was booked at 8 a.m., we'll put you at noon. This one was booked at 10 a.m., we'll put you at 3. To determine when the person was taken into custody would require that clerk to go back and get the body cam and watch for 20 minutes until the person is put into handcuffs. that number isn't recorded on the arrest report in the way that the booking time is. The booking time is, that's why I gave the previous example of clocking in. That's when you clocked in. Now, if there's a dispute and that person says, hey, I got taken into custody 8 hours earlier, you could go back and check it. But to go back and check it is like trying to check what time you left the house this morning. You don't clock in at the time that you leave the house. We can estimate 16 minutes probably, and if it was 30 minutes, that makes sense. 2 hours, wow, that's outside the time frame, and that's why we put the 8 hours in there. The second reason that the time that someone's taken into custody is not as easily identifiable as the booking time is that it is a constitutional question when somebody is in custody. Somebody is in custody when they are no longer allowed to leave. And sometimes that is before somebody's put in handcuffs. Sometimes it's not until they're put in handcuffs. And this is something that attorneys debate frequently and vehemently, especially when it comes to statements that are made to police officers, because being taken into custody is what triggers your Miranda rights. And whether your Miranda has to be given to somebody depends on whether or not they're in custody. And whether or not they're in custody has to do with a whole lot of different factors about whether or not the person was allowed to leave, whether or not they knew they were allowed to leave. And so there are many cases where defense attorneys and prosecutors will come in and argue about a particular statement that was made at the time that, my client was sitting on the curb, and the prosecutor will say he wasn't in custody yet. He was still allowed to go. He only sat down because he was tired and he was scared. And I say he was scared and he didn't think that he was allowed to go. He was in custody even though the cuffs weren't on him. And it is a very large body of Fourth Amendment case law that governs whether or not that person is considered in custody. And so there's no way that we could possibly have that entire hearing and make that entire determination before the 48-hour hearing comes up. Now, certainly, we could go back on appeal, and if I won my argument that my client was already in custody and he or she didn't get a pretrial hearing for 48 hours until after that, I would also have a great argument for saying that their Valdez-Jimenez rights were violated. They didn't get their hearing in a timely fashion. But those are the exceptions to the rule. For the vast majority of cases where you don't have an argument about when somebody came into custody and that time frame isn't much longer than 2 to maybe 3 hours, and you're having the pretrial release hearings within 24 hours anyway, it's simply a one less burden to put on that clerk to go from the time of booking to the pretrial release hearing.
Follow-up, please?
Yes, please,
Okay,
Assemblyman.
so I understand your concern about, do we really know when? I guess I'm still surprised that when you do put them into your handcuffs and in the car, that's not a recorded time. Is that really so burdensome to say to the peace officer, you have to record the time? Is they don't have time for that?
Melanie Scheibel, for the record, I can't speak to the burdensomeness or how onerous it would be to change the process. All I can tell you is that the way that the process is currently set up, the time stamp that the clerk gets is the booking time. That's the one that is communicated from the jail to the court.
Okay, so let me ask this question, because the concern is really about adding extra time onto these 48 hours. And so again, if we're operating in our Clark and Washoe minds, there's a different practicality here. However, if I'm in a rural community, and I'll say rural county, and there's a traffic stop, it's very possible it's a 3-hour drive to get to the jail. So again, we're trying to talk about all of this additional time, and yet we know that from the moment that the police, however they stop you, whether you're in a vehicle or whatever it is, there has to be some time. Police officers required to make records and reports of everything they do. There's video, there's the time you logged in to run their plates or their license. So I understand if you're saying that the time that's communicated the process is that the booking time, that's what gets communicated to the courts. But that's not the exact same question as asking when the actual time is recorded. And if so, if we have all these other mechanisms to that record and prove that time, why aren't we starting at that? Because what I also, the other idea that people can just leave before they're arrested or booked, and then saying that, you know, you defend people and they could have just left. Like, let me know when in the case that's ever true. Because if that's the case, then the moment the police officer pulls someone over and says, you were speeding, that person could literally say, no, I wasn't, and drive away. But please let me know what would happen if that person said, no, I wasn't speeding, or no, I didn't blow that stop sign and just drove away.
So Melanie Scheibel, for the record, let me clarify that generally what I'm arguing for my clients is that they were in custody at the time that they're sitting on the curb because they weren't allowed to leave, and that they are entitled to have their Miranda rights explained to them at that moment in time. It is generally the prosecutor and the police officer who will argue that they were not in custody and they were free to leave, because we all know that being legally free to leave and actually knowing that you're free to leave are two very different things. I also want to hand this over to Ms. Walker because I think it might help to understand. We did reach out to as many jurisdictions as we could reach before this hearing to ask about the average time between taking somebody into custody and booking them, and she has those numbers.
Thank you, Chair Miller and members of the committee. For the record, Mary Walker. I did reach out to several organizations, counties, and try to get the typical time from arrest to booking for several of the rural counties. For the most part, it's within 1 hour, and that's for Carson, Churchill, and Douglas, and Nye in Tonopah, and White Pine. For Nye County in the Pahrump area, because they have more, distance, there. And if they, typically what the officer would have to do is we don't have somebody to take blood tests in the jails or whatever. We have to take them to the local hospital. So even if you add the driving time, the taking the blood test and that type of thing, typically it's an hour, but it can go up to a couple of hours. Like in Pahrump, if you have all those things in there, it could be 3 to 4 hours to get all that done. But that, again, is if they need the blood test and all of those other things. So it's very, very, they're very prompt in trying to get this done. In Lincoln County, they were 2 hours. And the only one that had the problem, Mr. Perot talked about, that was Lyon, and they have a lot of problems with, they have a huge vacancy in their jail, and they are a county with a very, very large landmass. They have, it's 2,000 square miles is their county. So but one of the things I thought about the 8 hours, and I discussed this a little bit with public defenders, is so if you have an outlier, like Lyon County was more than 8 hours. They know this, they are working on this, and they're trying to get that resolved. But I think having that 8 hours in there is going to make them be better, to get their time frames down, to be within that, so that they don't go over that. I thought that was a good incentive for them to make some improvements. Thank you, Madam Chair.
And with that, that's exactly what we're all speaking to, is trying to get it better. Because it's not that we don't understand the technicalities, the traffic, the blood testing, the geography, the interrogation, all of this. But when you're the person who has been detained and you're the person that's going to be locked in jail, it's a different perspective. And so For this person, the clock really stands still. And there are constitutional rights that we're here to protect. So that's literally what everyone's trying to do, is to tighten this up. And so not that there's all these additional hours on top of this 48-hour standard that we've put in place, but again, considering what is this like for the actual person that is now in jail and what they're going through at this moment, where all they want to do is, because again, we're also talking how long before they can actually make that first phone call, before they can actually call an attorney or call their parents or call their spouse or call someone for help to let them know what's going on. So this is what we're getting at. We have another question from Assemblywoman Gallant.
Thank you, Chair. So I'm curious, in the event that, okay, let's just scenario case, high-speed car chase, the driver gets into a horrible accident but doesn't pass away, so now he or she has to be transported to the hospital. What does that 48 hours look like if maybe that person is unconscious for several days, or if they're in and out of surgery for several days? How does this timeline work with custody, booking, hearing in a case like that? And I know we have Mr. Hunt over here. I don't know if maybe he would want to talk about that process as well, if you guys are okay with that. I'd like to hear both sides of it, from process to also like just legally how that would play out.
Melanie Scheibel, for the record. I'd be happy to have Officer Hunt weigh in here. I can say that they can be booked at the hospital as well, so we would still be able to get that booking time. And I would suggest that that would be good cause to continue the hearing for 48 hours.
Except for, hold on a second, I'm sorry, I didn't call anyone up. What was your question?
I'm just curious about like what the process is. He has to go through it. I know, you know, like from doing and then knowing. I would just curious.
Yeah, what we're gonna wait on that.
Okay.
So,
Miller, may I add one more thing?
yes, please.
For the record, Mary Walker. Yeah, one of the things that I found in talking with these justice courts in particular is they're very confused when the time of arrest is. There's a lot of different types of interpretations. As Chair Scheibel, spoke to, it's a discussion in a lot of courts. But just practical on the ground, they are very confused on what it is, and there's different interpretations. My background is I'm a CPA, and so I want clarity. I want to know where you start, and I know these judges do also. It's very difficult on the ground to try and determine what the time of arrest is. So I just wanted to add that. Thank you, Madam Chair.
Thank you for that. And with that, we will go ahead and open it up for testimony. Anyone here in support of Senate Bill 235? Starting here in Carson City?
Thank you, Chair Miller, members of the committee. My name is Tom Clark. I'm here on behalf of the judges of limited jurisdiction, and I very much appreciate this conversation that's taken place this morning. I really want to thank Senator Scheibel, Senator Wynn, and Senator Harris, and the many, many, many stakeholders I think that you'll hear from today that have been working on correcting this and fixing this particular problem. The goal here is that we have equal justice regardless of population, regardless of where you are, urban or rural. And I think that the amendment that was brought forward gets us to that place so that the judges understand that this is a very important issue, that these defendants have their bail hearing within this 48-hour time period. What we were trying to address was, do we have the personnel? Do we have the judges? What if a judge is sick? What if a judge is on vacation? This process outlined in the amendment, I believe, gets to that particular place. Thank you, Chair.
Thank you, Chair Miller, members of the Assembly Judiciary Committee. My name is John Jones, and I'm here on behalf of the Nevada District Attorneys Association in support of SB 235. On the Senate side, we did oppose this bill. At that point, we thought the bill did not go far enough in addressing some of the concerns that we had related to the passage of the bail statute last session. And at the time, Chair Scheibel did promise that she would sit down with us and others and work through those concerns. And Mr. Pirro was at the table, I was at the table, judges were at the table. Nobody got everything they wanted with the compromise piece that is before you today. But it is moving us in the right direction. From a county and DA point of view, it provides more flexibility for us to get the 48 hours done. It is taxing our system. Again, I will remind you, when bail was passed last session, not one dime was given to the counties to make it happen. Not one dime. And I think Assemblyman Gray, when he was a commissioner, can talk about, especially from the rural perspectives, the issues the counties had getting this off the ground. But they did it.
Mr. Jones, can you wrap up your comments?
Gladly. I'm happy to answer any questions. I actually handle these hearings in Clark County, so if anybody has any questions about how they are handled procedurally, I'm more than happy to answer them.
John Pure for the record from the Clark County Public Defender's Office and testifying on behalf of the Washoe County Public Defender's Office as well. I was extremely grateful for this body when we passed the bail reform and looking at the Valdez-Jimenez opinion and putting that into action and making sure that everybody, regardless of where they are in Nevada, gets a prompt hearing, right? Because we are innocent till proven guilty, and that's a bedrock foundation. And making sure that everybody across the state gets the same type of justice is very important to me. There's an awesome article in the Nevada Lawyer that breaks all of this down, written by John J. Pirro. I suggest that we could pass it along to the committee. We all did sit at the
20
table.
copies, please, sir.
Certainly.
We all did sit at the table together and try to figure out the best way to move this along after we had 2 years to figure out some of the issues with the passage of that bill. I'm grateful to the stakeholders that are moving this along and to this body looking for the best way to make sure that equal justice is applied across the state.
Thank you, Chair Miller and members of the committee. For the record, Jennifer Berthume, Government Affairs Manager at the Nevada Association of Counties. We would like to thank Senator Scheibel, Harris, and Nguyen for their willingness to work with all of the stakeholders on this. As a result of the bill passed in 2021, the 48-hour provision has been the largest fiscal impact to rural counties. NACO supports the amendment presented to SB 235, which allows for relief from the fiscal impacts and the ability to continue to effectively implement the 48-hour rule. Thank you.
Is there anyone in Las Vegas that would like to testify in support of Senate Bill 235? Not seeing anyone. Broadcasting, will you open the lines?
There are no callers at this time.
Thank you. Then I will open it up for opposition testimony for Senate Bill 235. Is there anyone here in Carson City? Not seeing anyone. I don't believe there's anyone there in Las Vegas. Broadcasting, will you open the lines, please?
There are no callers at this time.
Thank you. Then I will open it up for neutral testimony for Senate Bill 235.
Thank you, Chair and members of the committee. My name is Marcy Ryba, M-A-R-C-I-E-R-Y-B-A, and I serve as the Executive Director of the Department of Indigent Defense Services, and we are working to build resilient and sustainable indigent defense systems with our rural counties. One thing that we've seen is that in these rural counties, it's the same attorney that's appearing 5 days in court and also that 6th day for the 48-hour hearing. We heard from one attorney that like to alleviate stress by going chucker hunting on the weekends, but he would have to leave early to come back to do these hearings. We heard from another attorney that wanted to travel to Reno to go shopping and had to sit in the hotel room waiting for this hearing to be resolved before she could go with her sister to continue shopping. There are a nationwide shortage of indigent defense providers. We're seeing this burnout with the fact that our public defender's office for the state is 44% vacant at this point in time. And we believe that what this is set forward in Section 3 will provide relief for our indigent defense providers so we can work with the counties to have someone other than those same attorneys always providing that representation at every hearing. We also appreciate Section 1, subsection 6, which clearly allows those remote appearances. In some of our smaller counties like Esmeralda County, the public defender lives in Pahrump, which is 4 hours away from Goldfield. So requiring that attorney to appear in person on a weekend would require an 8-hour round trip plus that hearing. We also appreciate that the county public defenders can receive this additional amount and that there will be similar language in NRS 180 for the state public defender to also receive this. Thank you.
Thank you. Is there anyone else here in neutral? Not seeing anyone in Las Vegas. Broadcasting, will you open the lines?
There are no callers at this time.
Okay, thank you. Then I will welcome the bill presenter back up for any final comments.
Thank you so much. I just want to reiterate that this has been a tremendous group effort, and I don't know if I thanked all the stakeholders for coming to the table multiple times on this, but happy to answer any additional questions now or offline.
Thank you so much. And with that, I will go ahead and close the hearing for Senate Bill 235. Our last item on the agenda today is public comment. So if there's anyone that would like to make public comment about anything not pertaining to the 3 bills we heard today, please come forward. Not seeing anyone in Las Vegas either. Broadcasting, will you open the lines?
The public line is open and working, but there are no callers at this time.
Thank you so much. Then with that, I will go ahead and close public comment. Thank you, members. We accomplished multiple things on our agenda today. And so with that, I will go ahead and adjourn today's hearing and see you back at 8 a.m. tomorrow morning. This meeting is adjourned.